Dear students, in this module we will cover the aspects relating to legal instruments on international migration. Specifically, we will try to learn about the instruments that are pertaining to protecting the interests of refugees, migrant workers, and also the kind of legal instruments that are in place and that are ratified by various governments with regard to trafficking related issues. International normative framework on international migration includes several aspects, including instruments relating to human rights of all the migrants, rights of the migrant workers, and protection of refugees. And these instruments are designed to combat migrant smuggling and human trafficking. Through these instruments, one can address the issues relating to migrant smuggling and human trafficking. Let us now look at the ratification of these legal instruments. These legal instruments have been ratified in varying degrees by the member states. As on 6th of October 2015, the legal instruments designed to protect refugees or to combat migrant smuggling and human trafficking had been ratified by more than 3/4 of the member states. The instruments which are legal in nature, protecting the rights of migrant workers, had been ratified by at most 1/4 of all the member states. This figure 1 indicates the status of ratification of various legal instruments that are related to international migration. The time reference was 1950 to 2015. So, over the period of time, namely 1950 to 2015, the kind of progress we have made in terms of ratification of the various legal instruments by the governments is indicated in this chart. The chart indicates the status in terms of number of states that have ratified various legal instruments, including the 1951 Refugee Convention, 1967 Refugee Protocol, 1990 Migrant Workers Convention, 2000 Human Trafficking Protocol, 2000 Migrants Smuggling Protocol, 1975 ILO Migrant Workers Convention number 143, 1949 ILO Migration for Employment Convention number 97, and 2013 ILO Domestic Workers Convention number 189. There has been substantial increase in the extent of ratification of some of the protocols and legal instruments, as we can see, whereas some have not seen that much acceptance in terms of ratification by the member states. Particularly the 1951 Refugee Convention, it has been ratified by many of the countries. Similarly, the 2000 Human Trafficking Protocol, it has also been ratified by many of the countries starting from 2000. So, this chart indicates the kind of progress in terms of ratification of various legal instruments. Many of the countries have accepted the importance of ratification of these instruments. Let us continue the discussion about the legal instruments that are meant for protecting the interests of refugees. The 1951 Convention followed by the 1967 Protocol both relate to the status of refugees, and these two instruments are central elements in international regime of refugee protection. The 1951 Convention defined the term refugee and also enumerated rights of refugees, besides establishing legal obligation of the states to protect refugees. The convention also prohibited expulsion or forcible return of persons accorded refugee status. It says that no refugee should be returned in any manner to a country or a territory in which his or her life or freedom would be threatened. This is the principle of non-refoulement. The 1967 protocol extended application of the 1951 convention to persons who became refugees. The 1967 protocol extended application of the 1951 convention to persons who became refugees after 1st January 1951 without any geographic limitations. As on October 2015, the 1951 convention and its 1967 protocol had been ratified by 155 out of 146 by October 2015. 1951 convention and its 1961 protocol had been ratified by 145 and 146 UN member states respectively, with 143 state parties having acceded to both the instruments. The 148 states that had ratified either 1951 convention or 1967 protocol hosted collectively 9.6 million refugees in 2015, or slightly less than half of the global refugee population. It is quite natural that these countries hosting slightly less than half of the global refugee population expressed their concern towards the interests and welfare of refugees and ratified the legal instruments that are meant for protecting the refugees. Now, let us move our attention to the legal instruments that are meant for protecting migrant workers. The International Labour Organization ILO has adopted 3 legally binding instruments, and all these 3 are directly relevant for protecting migrant workers. Let us look at these 3 instruments adopted by the states with reference to the migrant workers. The number 1, Migration for Employment Convention, revised 1949, the number is 97. The second one is Convention concerning migrations in abusive conditions and promotion of equality of opportunity. The third one is Treatment of Migrant Workers, Supplementary Provisions 1975, number 143, and Convention concerning Decent Work for Domestic Workers 2011, number 189. All these 3 instruments have complementary non-binding recommendations. The 1949 Convention number 97 covers recruitment and also promotes standards regarding working conditions of the migrant workers. That means, this convention covers recruitment as well as the working environment of the workers who migrated. This convention established principle of equal treatment of migrant workers and nationals with regard to laws, regulations and administrative practices that are related to living and working conditions, remuneration, social security, employment taxes and access to justice. All these aspects are very crucial to protect the interest of the migrant workers. Now, let us talk about the 1975 Convention number 143. This was the first multilateral attempt aimed at addressing irregular migration and to call for sanction against that. On the other hand, the 2011 Convention number 189, which came into force in 2013, was the first multilateral instrument to establish global labor standards for domestic workers, and this convention guarantees them the same basic rights that are enjoyed by other workers. This convention also established that domestic workers, regardless of their migration status, have the same basic labor rights as other workers, including reasonable hours of work, a limit on payment in kind, and clear information on terms and conditions of employment. So, through these measures, the interests of domestic workers are protected. With the help of this convention, domestic workers can also enjoy the same rights that are enjoyed by other workers. So, it brings in parity between all the workers irrespective of the status of migration. The discrimination against migrant domestic workers is addressed with the intervention of this convention. Employers of domestic workers, according to the convention, must respect the fundamental principles and rights at work, and these include freedom of association and the right to collective bargaining. As on 6th October 2015, 49 ILO member states ratified the ILO Convention number 97, and 23 member states ratified the Convention number 143. On the other hand, 22 member states ratified the Convention number 189. Thus, in totality, only 3 of the ILO's 186 member states, Italy, the Philippines and Portugal, ratified all the 3 instruments. Means many member states ratified one or the other of the conventions, whereas only 3 countries, Italy, the Philippines and Portugal, ratified all the 3 instruments. These 3 countries, namely Italy, Philippines and Portugal, represent less than 2% of the ILO member states, and these 3 countries, Philippines, Portugal and Italy, hosted less than 3% of all the international migrants worldwide. The 1990 International Convention on Protection of Rights of all migrant workers and members of their families is the third and most comprehensive international treaty on migrant rights. The 1990 International Convention established international definition for categories of migrant workers. The convention also formalized responsibility of states in upholding the rights of migrant workers and members of their families. Office of the High Commissioner for Human Rights was entrusted the responsibility of monitoring implementation of this convention, and the Office of High Commissioner for Human Rights also made attempts to further the ratification of this convention. As on October 2015, 48 member states ratified the 1990 convention, and collectively these 48 member states hosted 18 million international migrants as on 2015. In terms of proportions, these countries were hosting about 7% of the global total migrants. None of the state parties to the convention were major migrant receiving countries, and this has to be noted, and only 5 of them hosted more than 1 million international migrants. Overall, 93 countries ratified at least one of the 4 instruments regarding migrant workers. So, we had 4 instruments relating to migrant workers and their interests. Of these 4, 93 countries had ratified at least one of them. Together, these 93 countries hosted 35% of the global population of international migrants as on 2015, or around 85 million migrants were hosted by these 93 countries that ratified at least one of the 4 instruments relating to migrant workers. Now, let us move to the third aspect. We so far discussed about the legal instruments for protecting refugees. We also have looked into the legal instruments that are meant for protecting migrant workers. So, let us now talk about the legal instruments relating to smuggling and trafficking. 2 protocols seeking to stem irregular migrant concern, human trafficking and migrant smuggling. These 2 protocols supplement the UN Convention against transnational organized crime. The 2000 protocol to prevent, suppress and punish trafficking in persons, especially women and children, came into effect in 23, and as of 6th October 2015, this protocol had been ratified by 167 UN member states. This protocol defined human trafficking as acquisition of people by improper means. These improper means include means such as force, fraud or deception with the aim of exploiting them. So, this protocol gives clear definition about the human trafficking and the dimensions of human trafficking. This protocol aimed to prevent and combat trafficking in persons, to protect and assist victims of such trafficking, with particular reference to women and children, and to prosecute perpetrators of such crimes, besides promoting cooperation among the state parties. The 2000 protocol against smuggling of migrants by land, sea and air came into effect in 2004. The 2000 protocol against smuggling of migrants by land, sea and air had been ratified by 140 UN member states as of 6th October 2015. As set out in the protocol, smuggling of migrants involves procurement for the sake of financial or other material benefit of illegal entry of a person into a state of which the person is not a national or permanent resident. So, the protocol clearly specifies about smuggling. It had components like the financial or material benefit or illegal entry of the person into a state to which he was he does not belong. This protocol has proven to be an effective tool in combating and preventing smuggling of human cargo. This protocol also reaffirmed that migration in and of itself is not a crime. That means migration per se is not a crime, and that migrants may be victims in need of protection. The UN Office on Drugs and Crime, UNODC, provides assistance to the member states in implementing the two protocols. The rapid increase in ratification of human trafficking and migrant smuggling protocols perhaps reflects a growing concern among the member states with regard to involvement of organized crime in irregular migration. This indicates the strong resolve of the member states to fight against the crime involved in irregular migration, which is an organized crime as perceived by many of the member states. As of October 2015, extent of ratification for the conventions and protocols that we discussed so far differed to a great extent by development, group and major area. For the 1951 convention and its 1967 protocol, both relate to the status of refugees. The rate of ratification is low in Asia, it was about 40%, and in Oceania it was about 57%. The remaining areas indicate ratification rates above 80% for at least one of the two instruments. The ratification rates of protocols relating to human trafficking and migrant smuggling are found to be highest for the member states from Northern America, universal for both the protocols. Latin America and the Caribbean recorded figures of 100% and 91% respectively for protocol 1 and protocol 2. The Europe also recorded very high level of ratification at 95% and 91% respectively. The rate of ratification of the two protocols was also found to be higher among the countries of developed regions compared to the countries of developing regions. That means the ratification happened in a bigger way in the developed countries compared to the developing region countries. Now, let us summarize the learnings from this module. This module essentially covered the various legal instruments that have been ratified by the member states in relation to three aspects of international migration. Number 1 was about refugees, number 2 was about migrant workers, number 3 was about human trafficking and smuggling. So, the legal instruments on international migration are crucial in protecting the interest of migrant workers and people who migrated. We also have seen the role of these instruments in protecting the interests of migrant domestic workers. The instruments mandate the states to ensure protection and parity and equity and equality and no discrimination at all between the migrants and non-migrants. These instruments are designed to combat migrant smuggling and human trafficking. For instance, the 1951 Convention and 67 Protocol both relate to the status of refugees, and many member states had ratified these convention and the protocol. ILO adopted the 3 legally binding instruments that are meant for protecting the interests of migrant workers. 93 countries ratified at least one of these 4 instruments that pertain to migrant workers, and these countries hosted about 1/3 of the global population of international migrants as on 2015. And we also discussed about the responsibility of monitoring the human rights and implementation of the convention. We also have seen the involvement of High Commissioner for Human Rights in the task of monitoring implementation of the conventions and furtherance of the ratification of these conventions. We also looked into the protocol against smuggling of migrants by land, sea and air, which was proved to be very effective in combating and preventing smuggling of human cargo, and the kind of increase in ratification of human trafficking and migrant smuggling protocols perhaps reflects the growing concern among the member states with regard to involvement of organized crime in irregular migration. So, this module has helped us to get a fair understanding about the legal instruments that are used to protect the interests of 3 types of migrants: number 1 refugees, number 2 migrant workers, and finally the human trafficking related and smuggling related aspect and the migrants related to this category. We also have seen the extent of ratification of these protocols and conventions relating to the 3 vital aspects of international migration. Thank you so much.